I rise to speak to Amendment 502YP, which stands in my name. This amendment goes to the heart of how government power is exercised under this bill. It requires the Secretary of State, when issuing guidance or reviewing parental appeals, to act in a manner that's substantively fair, proportionate, and consistent with both the best interests of the child, but also taking into account the burdens they might impose on families and parents. Why is such a provision necessary? Because it's not enough for ministers to draft guidance that looks acceptable on paper, or to frame decisions in language that appears compatible with human rights law. What matters is how these powers operate in practice, how they impact both parents and children and other stakeholders in their daily lives. My lords, too often many innocent families I've spoken with experience the gap between theory and practice. They're told that regulations are light touch, yet find themselves deluged with data requests, threatened with attendance orders, or subject to investigatory processes triggered not by evidence of harm, but often by mere administrative suspicion. From my work with home educating families, I've heard repeatedly of parents treated as problems to be managed rather than partners in their child's learning and well-being. That's not safeguarding, it's coercion disguised as oversight. I understand that the guidance-led approach and strategy the government has taken is a means to try and block loopholes both now and into the future. But I would urge the Minister and the Department to really think about the costs that this sort of Henry VIII-led approach takes. You're imposing on families, many of them who find themselves on the wrong side of an investigation. And remember, the majority of those investigations don't ever lead to a conviction, having to pay huge court fees and set aside years of their life to fight for their rights, putting costs onto ordinary citizens. This amendment seeks to ensure that courts, when reviewing such actions, look beyond the fine words of official guidance to their real-world effect. Does the policy genuinely protect children, or does it impose burdens that are unnecessary, unfair, or disproportionate? Does it still respect the primacy of parents under Section 7 of Education Act 1996, or does it erode it by stealth? The principle of substantive fairness is well established in case law. The Supreme Court has affirmed that state interference with family life must be proportionate, necessary, and justified by evidence of significant harm. In R.W. versus Birmingham City Council, the court stressed that suspicion alone is insufficient to override parental decision-making. And in Strasbourg jurisprudence, cases such as TP and KM in UK and Folgero versus Norway make clear that formal compliance of Article 8 is not enough if in practice families are subjected to arbitrary or excessive state interference. This is not only about legal safeguards, it's about rebuilding trust. Parents must have the confidence that when the Secretary of State issues guidance, it's designed to support, not to harass or empower, not to intimidate. They must know that appeals will be judged not by a tick-box reading of regulations, but by a substantive assessment of what is fair, proportionate, and in the best interests of their child. Let's take one example. Guidance might say that local authorities may request information as necessary. On its face, this sounds reasonable, but in practice, families have been reportedly being asked for intrusive details about their beliefs, philosophies, or private lives, information far beyond what's needed to confirm that a child is receiving suitable education. Under my amendment, a court will be obliged to ask not just whether the words of the guidance seem lawful, but whether its actual application crosses the line into disproportionate intrusion. Consider parental appeals as well. Without a substantive fairness test, the Secretary of State could uphold decisions that technically meet the letter of the law or guidance, but are manifestly unjust, such as refusing deregistration when a child is in acute distress or supporting disproportionate monitoring conditions that make family life untenable. This amendment requires that such decisions be tested against their effect on the ground. Some may fear this opens the door to endless litigation. I'd argue the opposite. By embedding a principle of substantive fairness from the outset, we give clearer guidance to decision makers, reducing the scope for arbitrary or heavy-handed action, thus reducing the likelihood of judicial review. It's precisely when parents and families feel trapped, unheard, and mistreated that they resort to the courts. My lords, this amendment isn't limited to home educators. It will protect all families affected by this bill. Schools, too, will benefit if guidance remains targeted and proportionate, rather than bloated with impractical demands. Local authorities, often stretched to breaking point, will be shielded from the impossible task of enforcing rules that look neat in Whitehall but are unworkable on the ground. It also respects the proper role of Parliament, of this place. Too often we legislate with the assumption the Department will interpret and apply the law reasonably, but when guidance becomes overreaching or unfair, it's our reputation that suffers. This amendment restores a crucial check, ensuring that actions under the Act under the bill are judged by their substance, not their spin. Finally, I stress that this does not prevent the Minister from issuing robust guidance where children are genuinely at risk. What it does require is that such guidance be necessary, proportionate, and practically implementable without undermining parental and family rights. That's exactly the balance struck in our domestic law and by the European Court of Human Rights. Protection where there is evidence of harm, but restraint when there is not. My Lords, if we pass this bill without such safeguards, we risk embedding a culture of formal compliance that is blind to lived reality. We risk measures that look lawful and feel great about them, but feel unjust. And in doing so, we risk losing the trust of the very parents and families and children whose partnership we need to safeguard children's lives effectively. Amendment 502YP offers a principled, proportionate solution. It ensures the law is not just words on paper, but fairness in practice. It strengthens oversight, protects families, and upholds the integrity of our child protection system and education system. I commend it to the House.
Finally, Amendment 502YP, tabled in the name of the Noble Lord Wei, would require the Secretary of State, when issuing guidance or reviewing parental appeals, to act in a way that is substantively fair, proportionate and consistent with the best educational interests of the child. We don't believe this amendment is necessary for several reasons. Firstly, primary legislation is neither appropriate or proportionate in this case. Ministers are required to comply with the public law principles of acting reasonably and following a fair and transparent process. And in any event, consideration by the courts will be more broad than the wording and stated intention of guidance and policy in determining human rights compliance. Secondly, we must be wary of unintended consequences. The best educational interests of the child will not necessarily always be the first priority in all guidance and determination of appeals arising from this bill, as of course its scope encompasses areas other than education. For example, it's possible that there could be well-being or safeguarding matters that override educational interests in some circumstances. Thirdly, where this government consults with children and young people and where we assess potential impacts of new policy and interventions on the very people they're intended to serve, including through child rights impact assessments, I can reassure Noble Lords that these processes are neither superficial in their intent or execution, nor are they intended to shield actions from judicial review. For example, as I've already identified to the noble and learned Lady Baroness Smith, the government's National Youth Strategy engagement process has in fact developed into a very meaningful co-production process with young people and the sectors that support them, with over 14,000 young people being able to submit their views through the process that we have undertaken. That is the right way for government to ensure that children's voices are at the heart of the decisions that we are making. Equally, we will continue our work to ensure that child rights impact assessments will be delivered across government, and that children's rights and interests will be at the heart of decisions made by this government.
My Lord, so I rise to move Amendment 502YQ, which stands in my name. This is mainly really to probe the government's intention in relation to its own use of data regarding this bill. This amendment addresses an issue that has surfaced repeatedly in our many debates, the scope of data collection about children in education. We've heard a lot today about the role of technology providers, but I really want to turn the focus even onto how we're collecting data within the education system in government. My amendment would ensure that personal data may only be collected, retained or processed where strictly necessary to protect a child from significant harm, as defined in Section 31 of the Children Act 1989. Why is this needed? Because the bill as drafted gives wide latitude to local authorities and the Secretary of State to demand data on children not in school, an area that I really care about, as well as potentially on others. And in particular, the data demanded of children not in school, and we've already heard about the amount of data that's already collected on children in school, is off the scale. We're told this is for safeguarding, but safeguarding in law has a very specific meaning. It's not a license for limitless information gathering. It's a duty to act when a child is suffering or likely to suffer significant harm. Yet Clause 31, for instance, invites local authorities to gather information far beyond what's necessary. Names, addresses, dates of birth are sufficient to identify a child and discharge oversight duties. But the bill's wording allows for much more. Details of parental, children's beliefs, educational philosophies, supplementary providers, even protected characteristics. This, to me, is mission creep, not proportionate oversight. As the Parliament has acknowledged itself in past consultations, the bare minimum of data suffices to track children and ensure no one falls through the net. To demand more because it might be helpful is not lawful data processing. Data protection law is clear. Collection must be limited to what's necessary for the purpose. Helpful is not enough. My lords, the risks of excessive data collection are not theoretical. Families have already seen sensitive information stored indefinitely, cross-referenced with other records, and sometimes shared with agencies in ways they did not consent to or even know about. One military family I spoke to, interacted with, recounted how their local authority repeatedly contacted the father's workplace about his children, despite clear instructions not to do so. Another home-educating mother described how after deregistering a child with special needs, she was followed in public after being wrongly referred to social services. These are not safeguards, they're intrusions to undermine trust. We must remember too that not all parents in the system are confident or well-resourced. Some are vulnerable, fleeing domestic abuse, or suffering with SEND bureaucracy. For them, intrusive data demands feels less like protection and more like surveillance. If the state is perceived as hostile, families may retreat from engagement altogether, making genuine safeguarding harder, not easier. That's why my amendment ties permissible data collection to the Section 31 threshold. That threshold, significant harm, is already the bedrock of child protection law. It's the line our courts have drawn between parental primacy and state intervention. Aligning data powers with that line ensures consistency, legality, and proportionality. Subsection 2 of my amendment ensures proportionality by limiting data to what is essential for the specific risk identified. If concern is neglect, collect information relating to neglect. If the concern is radicalization, focus on that. Do not use safeguarding as a pretext for wide-ranging dossiers on families' private lives. Subsection 3 closes off another danger, profiling. We should not be gathering data to build long-term behavioural profiles of children or to monitor families against vague benchmarks of compliance. That's not safeguarding, it's social engineering by stealth. And subsection 4 requires the Secretary of State to publish clear guidance within 6 months so that local authorities, schools and parents know the limits of permissible data collection. That guidance should provide clarity, consistency and accountability. Some might worry this ties the hand of professionals, these amendments. On the contrary, it frees them to focus on what matters. Instead of drowning in forms and files and data, they can concentrate on children at genuine risk. Excessive data is not neutral. It diverts time, money and attention from where it's most needed. International law supports this approach. In MM versus UK 2012, the European Court of Human Rights held that the retention of excessive personal data without clear necessity breached Article 8. And in Ali versus UK 2015, the court stressed that decisions must be informed by accurate, relevant and proportionate information. We cannot claim compliance with Article 8 if we allow the indefinite harvesting of families' and children's private details just in case. And this amendment is not only for home educators, though their experience has highlighted this problem in the bill. It protects every family in the education system. It ensures that schools are not turned into data collection points for the state. It ensures that local authorities aren't saddled with the impossible burden of storing, processing and protecting sensitive information they don't always need. And above all, it protects children from being profiled, stigmatized or surveyed in ways that bear no relation to genuine safeguarding. My lords, in passing this bill, we mustn't create a database state by accident. We must legislate with care, remembering that data is not neutral. It's power. It's the new oil, in fact. Used well, it can protect. Used badly, it can harm. Amendment 502YQ ensures that power is exercised with clear limits tied to the statutory threshold of significant harm that's fair, proportionate and faithful to the principles of our child protection law. I commend it to the House.
Turning to Amendment 502YQ, tabled by the Noble Lord Wei. which seeks to restrict the personal data collected by schools unless it relates to significant harm. I have to say, we did discuss the data protection issues surrounding children not in school registers at some considerable length in the time that we devoted to those clauses earlier on in this committee. But we share a commitment to protecting children's privacy. But safeguarding is not just responding once harm and neglect has occurred, it's about preventing it. Schools are uniquely placed to notice the early signs, subtle changes in behaviour, patterns of concern and emerging needs. In the last year alone, schools made 126,000 referrals to children's social care. And beyond safeguarding, schools have a range of responsibilities that require them to collect and use data effectively. Restricting their ability to do so would not only hinder their work, but could leave them open to legal challenge for failing to meet their statutory duties. Elsewhere in the bill, we are rightly strengthening the role of education and childcare settings in multi-agency safeguarding arrangements, with a shift to prevention at the heart of our reforms. This is not about surveillance, it's about ensuring that when a child needs help, the system sees them, hears them and acts.
To speak to amendments 502YN and 502YR, which stand in my name. These amendments are bound by a common theme, that the powers we create in this bill must be effective, proportionate and accountable, not only in ordinary times, but in moments of crisis when authoritarian temptations grow stronger. Amendment 502YN would establish an annual review of all measures introduced by the bill. Each year, the Secretary of State would be required to test whether those measures are achieving their stated purpose and whether they're doing so without imposing unnecessary or disproportionate burdens on parents, children, schools, providers, local authorities, or the department itself. Where a measure fails, it should be amended or repealed, and if no action is taken, then within 2 years it must lapse. This is about accountability cutting both ways. Families, schools, community groups, huge numbers of stakeholders are being asked in this bill to account for the children's education. It's only fair that government should account for the laws it passes. We've been warned many times in these debates about the dangers of excessive bureaucracy and mission creep. Clause 31, the proposed register of children not in school, illustrates this risk. In principle, such a register may help identify who's being educated outside mainstream settings. In practice, the bill demands far more data than is needed. In Portsmouth, more than 70% of educated children have already been served with notices or orders annually, compared with a national average closer to 1%. That's not proportional oversight, it's overreach. And the effects ripple outward. Children suffer when teachers, social workers, SEND staff are forced to spend more time filling forms and supporting them. Parents are treated with suspicion, not because of evidence of harm, but because they made a lawful choice to educate differently. Schools themselves may be dragged down by compliance checks that drain morale and resources. Providers and tutors may be chilled by one-size-fits-all rules designed for large institutions, but applied indiscriminately. Community groups and charities, often the lifeline for struggling families and children, will find scarce volunteer time consumed by licensing and paperwork. We've seen where such unchecked bureaucracy leads. The contact point database was launched with the best of intentions to safeguard children. It collapsed under its own weight, disproportionate, unworkable, ultimately abandoned. Scotland's named person scheme likewise promised protection, but in practice extended excessive authority and intrusive data collection before being struck down. These are cautionary tales of what happens when there's no obligation to review, no sunset clause to cut away what does not work. And yet, my lords, the risks here are not only of inefficiency, there is something deeper. Bureaucracy, when excessive, is not neutral. It becomes a means of control. It erodes freedom not by open coercion, but by endless demands that exhaust and intimidate until families, schools, and communities yield. That's why Amendment 502YR is so important. It recognises that powers created in good faith can one day be misused. It requires that within 6 months of royal assent, the Secretary of State ensures a mechanism is ready so that in any national emergency or period of authoritarian governance, the courts, not ministers, retain the final authority to uphold the primacy of parental rights in their children's education. We cannot ignore the geopolitical context. Across Europe and beyond, we see the rise of extremes on both left and right. Authoritarian governments rarely declare themselves at the outset. They grow by increments, often beginning with education. They use registers and guidance powers not to support families, but to control them. They impose ideological curricula. They marginalise communities of faith. They stifle innovation and dissent in the classroom. And disturbingly, elements of this bill draw inspiration, whether knowingly or not, from an unlikely and troubling source. The original departmental human rights justification cited for state intervention, to justify state intervention in home education here, arose from a case in Germany where a home education parent was prosecuted under laws dating back to the 1930s. These laws, introduced under Hitler's regime, continue today to ban home education outright in Germany. It's sobering that our own debates now echo arguments first made to defend a system designed not to protect children, but to eliminate educational pluralism. One that our own national wartime government in the 1940s sought to fight by giving parents the ultimate say over children's education. We must not follow that path. We must not allow powers framed as safeguards to evolve into machinery that stifles freedom. This is not to deny the state its proper role in protecting children. Safeguarding is vital, but safeguarding fails when systems chase compliance instead of risk, when form-filling replaces human judgment, when bureaucracy itself becomes the end rather than the means. In such a climate, children most in need are overlooked, while families acting responsibly and schools are burdened and alienated. The two amendments before us are modest disciplines against such outcomes. The first creates a feedback loop. Parliament learns from the real-world impact of its laws and corrects course when necessary. The second ensures that when times grow dark, there's a constitutional anchor, that courts can guard against authoritarian misuse, ensuring parental primacy in education is never extinguished by bureaucratic or dictatorial creep. Together, they protect not only parents, but children, schools, providers, and communities. They rebuild trust that the state will focus its energies where they matter most, and that it will relinquish powers that do more harm than good. If this bill is to endure, it must not only serve well in fair weather, under whichever government today, it must be robust enough to withstand foul weather too, to guard against inefficiency in normal times and against authoritarian misuse in extraordinary ones. My lords, these amendments ask only that laws be judged by their fruits and that liberties be defended when they're most vulnerable. That's how we protect children more effectively, support families more fairly, and preserve freedom more securely. I commend these amendments to the House.
The amendments in this group cover a wide range of issues in relation to this bill, including review of the Act, disapplication and commencement. And I'll begin with Amendment 502YR, tabled by the Noble Lord Wei, which seeks to protect a parent's right to determine their child's education in the event of a national emergency or an authoritarian government by placing judicial oversight above executive restrictions. My lords, this amendment would actually be ineffective as quite rightly, Parliament is sovereign. Any law passed by a current Parliament can be changed or repealed by a future Parliament. Provided the education a child receives is both safe and suitable, existing legislation makes clear that most parents have the right to determine the form of education that best meets their child's needs. This we have, of course, discussed at length during the course of this committee stage, and the bill does not change that. Turning to Amendment 502C on reviewing the Act, can I start by commending the Noble Lord, Lord Norton of Louth's commitment to post-legislative scrutiny, which, as he himself identified, has been government policy since 2008 and part of the process for legislative progress throughout this House. I can remember the discussions around putting it into that position in my last period of time in this House. I supported it then, I still support it now, and in the interim period between 2010 and 2024, amongst the range of things that I was able to do, I was very pleased to be able to advise foreign governments about the significance of foreign parliaments, about the significance of post-legislative scrutiny, drawing on precisely the work of the Noble Lord and the experiences of this Parliament in putting those into operation. Alongside that amendment, we have Amendment 502YN, tabled by the Noble Lord, Lord Wei, which concerns a review of the operation of the bill's measures. As I say, this government agrees on the importance of having an appropriate mechanism for the proper evaluation of the impact of legislation and ensuring that it meets the goals that it sets out to deliver, especially given the size and wide-ranging ambitions of this bill in particular. I can assure noble lords that this bill will of course be subject to post-legislative scrutiny in the usual way without this amendment. We fully expect that this evaluation will be carried out within the first 5 years of the legislation coming into force. We recognise the importance of monitoring our progress in a timely and transparent way. So in addition to post-legislative scrutiny, we've already published our plans for monitoring and evaluation in the impact assessment for this bill. Bespoke reviews of policies will likely be conducted at a measure level or grouped measure level, depending on which is most appropriate, given their different objectives and metrics. We also intend to conduct a post-implementation review of the bill as per the Better Regulation framework. And what's more, many of the powers to create secondary legislation in this bill stipulate that such secondary legislation will be subject to the affirmative procedures. This will give Parliament the opportunity to further scrutinise and debate our plans. Regarding Amendment 502YN, tabled by the noble Lord Wei specifically, it is not this government's intention to impose unnecessary or disproportionate burdens on the sector. We've been absolutely clear about the bill's expected benefits and costs in our published regulatory impact assessment, which was green rated as fit for purpose by the Regulatory Policy Committee. As stated in that impact assessment, we anticipate the overall impact on society of this bill to be positive. Where there are additional costs to business and households, these have been minimised insofar as possible and are considered proportionate to achieve the positive safety, well-being, education and financial benefits to children and families. While of course the government will take action where the post-implementation review of the bill as per the Better Regulation framework identifies that objectives are yet to be met or improvements could be made, it would not necessarily be proportionate to repeal measures or make legislative changes in the way in which this amendment proposes. The government would quite reasonably want the flexibility to consider the best course of action.
I thank the Minister. Just one clarification. On my understanding, having spoken to those who know about the workings of the Regulatory Policy Committee, which apparently the Minister said green-lighted this bill, is that in the last few years they've not actually been allowed to ask for submissions upon receiving a draft bill to scrutinise whether that bill fits within the kind of good regulatory framework that we all would like to see. So the information that it had to greenlight this bill, I think, was very, very limited indeed, because if you can't ask people what they think of the bill, then obviously any information you have is very, very limited, and you can only go on what you've been given. Which is further ammunition, I think, for the point that this bill needs a lot of scrutiny, because it hasn't really had any before it was even brought before this House.
Well, just on the point about the Regulatory Policy Committee, the Regulatory Policy Committee did have the benefit of our published regulatory impact assessment, of course, to review, and wider comments about the efficacy of the Regulatory Policy Committee, I think, are for the noble Lord to make to them rather than use as a stick to beat this particular bill. And frankly, as we are coming to the end nearly of day 12 of committee on this bill, the idea that it has not had sufficient scrutiny, I think, is frankly laughable, given the time and care that was also spent in the other place, which has been massively exceeded by the time and care that has been spent by noble lords in this House during the course of this committee. I will, if necessary...
Yeah, sorry, just to clarify, the words I used were before it got brought to all of this place. I think the reason why it's had so many days of scrutiny is because it wasn't drafted in a way that was appropriate for, we've spent so much time, you can't believe how many nights and days we've all had to work on this. I think if we could have bills in future that had a little bit more effort put into their drafting, by policymakers and others, then we could actually use the time of this House really, really well. So I'm not in any way criticising or saying that the work of this House is any way wasted. In fact, it's been very, very necessary to get us to where we are today.
The Noble Lord is right that Noble Lords have spent considerable hours on this, some more than others, I think it would be fair to say.